State of California, County of Monterey, Department 14 is now in session. Honorable Judge Vasquez presiding. Please be seated and come to order. Please silence all cell phones and refrain from talking.
Good afternoon, everyone. Welcome to the Monterey County Superior Court, specifically the Monterey Courthouse. I want to start off by saying that it's an honor and a privilege to have the opportunity to preside over this mock trial competition. I've already had the pleasure and the benefit of being able to see many of you in action. And I got to say that this is truly going to be a great experience because I already know that I'm here in the presence of a lot of superstars that have a tremendous amount of talent and a great amount of skill. And it's a pleasure to be here and to watch you in action in this championship competition. So get ready to showcase your talents right here, okay? In any event, at this point in time, to help myself and the attorney scores, will the prosecution team state your name and your role, please?
Good afternoon, Your Honor. My name is Sophie Sperano. I will be the pretrial attorney in today's case. Now, may the trial attorneys please introduce themselves.
Yes, they may.
Good afternoon, Your Honor. My name is Ryan Eubanks, and I will be representing the prosecution in tonight's case.
Good afternoon, Your Honor. My name is Zara Kamara, and I will be playing a trial attorney in today's case. Now, may the witnesses please introduce themselves.
Good evening, Your Honor. My name is Nora Wilcox, and I will be playing the role of Cleo Schaefer this afternoon.
Good afternoon, Your Honor. My name is Phoebe Zyberg, and I will be playing the role of Dylan Mavis this afternoon.
Good afternoon, Your Honor. My name is Amanda Way, and I'll be playing the role of Ari Coach today.
Good afternoon, Your Honor. My name is Martin Wong, and I will be playing the role of Billy Scher today. Now, will our timekeeper please introduce himself?
Good afternoon, Your Honor. My name is Michael Blitch, and I'll be the timekeeper in today's case. Now, may the attorney coaches please introduce themselves.
Good afternoon, Your Honor. Susan Blitch. I'm one of the attorney coaches.
Good afternoon, Your Honor. John Eubanks, one of the attorney coaches.
All right, so defense team, please state your name and your role.
Good afternoon, Your Honor. My name is Shayla Dutta, and I will be arguing the pretrial motion on behalf of Jordan Franks.
Good afternoon, Your Honor. My name is Sophia Cho, and along with my co-counsel, Emma Brown.
Good afternoon, Your Honor.
We represent the defendant, Jordan Franks.
Good afternoon, Your Honor. I am Jade Marquez. Good afternoon, Your Honor. I am Ezra Weintraub.
Good afternoon, Your Honor. I am Carter Lucky.
Good afternoon, Your Honor. I am Jordan Franks.
Also with us are our courtroom officers.
Good afternoon, Your Honor. My name is Nicole Mursky, and I'll be the unofficial timer in today's case.
Good afternoon, Your Honor. My name is Brianna Shuto, and I'll be serving as the courtroom bailiff in today's proceedings. May I go over a few rules of this courtroom?
You may.
I'd like to remind the gallery that absolutely no food or drink is allowed in the courtroom. Water is permitted. If spectators must leave, please do so quietly to avoid disrupting participants. But finally, Your Honor, I have a copy of the rules of procedure on hand for the court's convenience.
Thank you very much.
Finally, Your Honor, our team coach, Mr. Shire.
Good afternoon, Your Honor.
Good afternoon, sir.
That concludes introductions from the defense.
Thank you, counsel. All right, so you must complete your presentations within the specified time limits. The clerk will signal you as your time for each section of the presentation begins to run out. When your total time for each section runs out, you will be stopped, even if you have not finished. Attorneys must call 4 witnesses within time limit. This is a bench trial. At the end of the trial, I will render a verdict of guilty or not guilty in relation to the charge brought. The teams will be rated based on the quality of their presentation, independent of my verdict. Barring unforeseen circumstances, no recesses will be called. If for any reason a recess is necessary, team members should remain in their appropriate places and should have no contact with spectators or coaches. Remember that objections are limited to the California Mock Trial Simplified Rules of Evidence located in the case packet. If there are no questions, the pretrial arguments will begin. So this hearing is called to order. Both sides have 4 minutes to present their arguments. The defense will begin. I will interrupt to ask clarifying questions. Time spent answering my questions is not included in the 4-minute time limit. At the conclusion of your arguments, each side will be offered 2 minutes of rebuttal time. Remember that the rebuttal time is to be used to counter your opponent's arguments. It cannot be used to raise new issues. Is counsel for the defense ready to begin?
Yes, Your Honor.
Please summarize your arguments.
Your Honor, Shayla Dutta for Jordan Franks. May it please the court. When the police coerced Jordan Franks to open her personal safe, a safe which contained sensitive medical records, they violated her Fourth Amendment rights, and the fruits of that search must be suppressed. Now, on the night of June 9th, 2022, Detective Mavis asked Ms. Franks to search her safe on board the Heart of the Ocean cruise ship. Your Honor, Ms. Franks was clear. She said no. But that and any subsequent refusals did not stop the detective, who, instead of then getting a warrant, stood and blocked the doorway and attempted to use the threat of a warrant to induce Ms. Franks' submission. Now, under the totality of the circumstances test laid out in Schneckloth v. Bustamante, the detective's conduct violated Ms. Franks' protection against unreasonable searches and seizures. Now, Your Honor, among the factors the court in Schneckloth identified that are pertinent in today's case are the nature of questioning and the length of detention. The nature of questioning, Your Honor, was misleading, and it created resigned inevitability.
How was it misleading, counsel?
Well, Your Honor, if I may invite the court's attention to page 38, line 5 of the record, the detective herself admits she told Ms. Franks a warrant was being authorized. Now, at this point, the detective had prepared a warrant application. She hadn't submitted it to a magistrate. She hadn't appeared before a judge. It wasn't being authorized.
Is there a case that you're particularly relying on to support your position as to that issue?
Yes, Your Honor, that would be United States versus Griffin. That's the only other case in our limited library in which a defendant, or in that case, a third party, initially unequivocally refused to consent.
Tell me about the specific case or facts of that case.
Yes, Your Honor, the police approached the defendant's apartment on suspicions of a stolen mail bag. They asked Russell, a third party, for permission to search, and Russell denied it, citing that he was entertaining. After the police had then apprehended someone leaving the defendant's apartment through a window, they returned to Russell, and Russell stepped aside, allowing them to proceed with the search. Now, the court held in that case that the police asking for consent multiple times was permissible because of the clear absence of any deception, misrepresentation, or trickery. That's not what we have in today's case. Because, Your Honor, even if Detective Mavis had submitted that warrant application, that warrant application was prepared before the officer ever entered Ms. Franks' cabin. She didn't know that safe existed. And because of the particularity clause in the Fourth Amendment, that warrant application wouldn't have included Ms. Franks' safe. A warrant was not being prepared, or, as she told Ms. Franks, about to be authorized or would be authorized at any minute. In fact, Detective Mavis didn't even know if once she submitted that warrant application, it would be processed in the next 24 hours. She led Ms. Franks to believe that a warrant was much more guaranteed and much more imminent than it actually was, and therefore under United States versus Griffin was coercive. We can also look to the cases of Bumper v. North Carolina and United States versus Hicks.
Tell me about the North Carolina case. What are the facts in that case, counsel?
Yes, Your Honor, police were investigating a defendant for a felony. They arrived at the defendant's grandmother's house and informed the grandmother that they had a warrant when in fact they did not. Now, she permitted them to search believing she had no other option, and the court held that that was not constitutional.
Why not?
Well, Your Honor, because by telling a defendant you have a warrant, officers are effectively saying they have no right to refuse a search.
In this particular case, did the detective say that he or she had a warrant?
No, Your Honor. We agree that the circumstances in today's case don't rise to the extreme level of that in Bumper, but the detective's statements, a warrant is being authorized and will be processed at any moment, have a similar effect on Ms. Franks, making her feel as though at any moment Detective Mavis will return with a warrant in hand. That refusing to consent is ultimately meaningless, when that wasn't really true. That she had hours, if not days, in which her privacy would be preserved had she not been overborne or misled by the detective. Now, Your Honor, the nature of this questioning also created resigned inevitability. At page 40, line 41 in the record, the detective tells Ms. Franks 5 or 6 times, "I'm going to open that safe whether you agree to it or not." Your Honor, even if one knows their rights, they start to feel in that moment as though asserting them is meaningless. Those statements of the detectives, they aren't informing Ms. Franks of any option she has. They're making...
Pardon the interruption, counsel. So you're talking about that circumstance right there rising to the level of causing some type of coercion or duress because of the repeated questioning. Is that correct?
Your Honor, the statement itself as well as the repeated questioning.
And quote to me the precise statement. How was the request framed?
Your Honor, initially, the detective just asked to enter that safe.
So the detective asked, did not order or direct. Is that correct?
Well, Your Honor, initially. Then, after Ms. Franks had refused multiple times, she said to her, "I'm going to open that safe whether you agree to it or not," at page 40, line 41 in the record. And just later, Ms. Franks also states she relentlessly requested she open that safe.
Isn't there any case that exists where you have a circumstance where the officer or the agent that's involved presents the suspect with the chance to select whether to consent or to simply wait for a search warrant to be issued? And also, in circumstances such as this, you talk about the repeated questioning, but aren't there other factors also to evaluate from a totality of circumstances standpoint, which suggests that there is no coercion overall when you look at other factors?
Yes, Your Honor, to your second point, the totality of the circumstances cased in Schneckloth does mention other factors, which we will shortly address. To your first point, we believe you're referring to the cases of People v. McClure and People v. Ratliff.
So tell me about the McClure case.
Your Honor, in the McClure case, officers essentially offered the defendant a choice between consenting immediately or waiting for them to obtain a warrant. Similarly, in Ratliff, the defendant was informed that if they did not consent to a search of their car, the officers would obtain a warrant and break into that trunk in the future.
So was offering that option to either consent or wait for the warrant to be issued, was that a significant factor that ultimately resulted in there being involuntary consent in those matters?
No, Your Honor. In those cases, consent was found to be valid.
Why?
Well, for a couple of critical reasons. In both of those cases, those officers were operating on good faith. They had a belief, a legitimate belief that they had probable cause to obtain a warrant, and they were completely honest with the defendant or the involved parties while they were questioning them.
So in this case, did the detective have probable cause?
Yes, Your Honor. The defense concedes the detective likely could have had probable cause.
And in this case, pardon the interruption, counsel. I apologize for interrupting you. Let me ask this question. Did the detective in this particular matter already proceed with the process of applying to get a search warrant reviewed by a magistrate?
She had not yet applied, Your Honor. She had prepared that application, but hadn't left the ship or submitted it at that point.
So she prepared an application. She already had probable cause and was already in the process of preparing it, or had prepared it. Is that correct?
Yes, we don't know for sure whether she had probable cause, as that warrant was never actually reviewed by a magistrate.
Do you think that's a significant fact here that is a little different than what you see in the Ratliff case, for instance?
Your Honor, we believe the most significant fact in today's case is not only that Detective Mavis was being mistruthful to Ms. Franks, but was using the possibility of a warrant as a threat, not an option.
Wouldn't that also be, and again, I apologize for interrupting you, counsel, wouldn't that also be analogous to a declaration of the legal remedies that an officer would be entitled to pursue in that instance? Isn't there a case that actually addresses that?
Your Honor, there is a case that addresses that. That is Ratliff, and no, it would not be analogous to that. In Ratliff, the officers told the defendant that absent his consent, they would obtain a warrant. That was truthful, and it was still offering that choice. In today's case, Detective Mavis told Ms. Franks, "I'm going to open that safe whether you agree to it or not," several times until she finally relented. That's not offering a choice, Your Honor. In fact, it's making it clear to Ms. Franks that she has none. And the critical difference as well from Ratliff to today's case is the detective's truthfulness. There were no statements in any of those cases in which a choice was offered and consent was valid that were inconsistent with where the warrant actually was. Telling Ms. Franks that warrant will be processed at any moment is clearly inconsistent with the fact that that warrant had not yet been applied for, and even if it had been, wouldn't have included the safe at issue. May I proceed, Your Honor?
You may.
Now, another factor under the Schneckloth test to consider is the length of detention. Now, Ms. Franks had been taken back to her cabin by the detective, who then stood in the doorway and later instructed her to stay in that cabin and not to leave. If custody exists when a defendant doesn't feel free to leave, that's proof Ms. Franks was detained at the time of this questioning. Now, the importance of custody as a factor is addressed in the case of Castaneda v. Los Angeles. In that situation, the defendant had been arrested and was in the back of a squad car. And although he had verbally consented to a search, took measures to misdirect the police from the proper house to search. Now, the court held because in that case the defendant did not have any power over whether or not that search was actually conducted, his consent was not voluntary.
In that case, he was also in handcuffs in a patrol car, transported to multiple locations because he was not being very upfront about where his true residence was in order to avoid having the officers search the place where he was staying at and where he had drugs illegally stored. Is that correct?
Yes, Your Honor.
So he was transported to different locations within the jurisdiction where they were operating. Here we're talking about a single cabin, right?
Yes, Your Honor.
And is there any case that you've come across that deals with the length of time that constitutes an undue prolonged time?
No, Your Honor, we don't have that specific fact in our limited library. And we'd like to acknowledge that the physical restraints present in Castaneda are greater than what we have in today's case.
Was the defendant in this case handcuffed?
No, Your Honor, nor was she arrested at that point.
Was not placed in the back of a patrol car either, correct?
Yes, Your Honor.
Was not at the police station, correct?
Yes, Your Honor. We do agree that the situations physically in Castaneda, that there were much more physical restraints in that case.
She was within the confines of her own cabin where she was staying at. Is that correct?
Yes, Your Honor.
Okay.
Your Honor, the reason that our case still can take standards from Castaneda is because not only did she not feel free to leave, but that the detective's verbal coercion, the statement she made to Ms. Franks, effectively amounted to the same effect on Ms. Franks.
Wasn't she standing by the doorway? Wasn't the detective standing by the doorway in order to give the defendant some space to operate to be able to open the safe that was inside the cabin?
Your Honor, that was the detective's stated purpose, but that's irrelevant to the issue in today's case, as it's not about what the detective intended to do, it's how a reasonable person in Ms. Franks' position would have perceived that action and how it would have affected their interpretation of the circumstances.
Understood. Thank you.
Your Honor, there are also a few other circumstances Schneckloth v. Bustamante mentions. That includes the age, the level of education, and whether Ms. Franks knew her rights. Now, Ms. Franks had graduated from high school, but beyond a few acting classes, had no education on top of that. She was a young woman without any power in this situation. And she knew her rights. Which raises the question,
1 minute.
why did she change her mind? Your Honor, the people are not going to be able to answer that question. Absent Detective Mavis's coercive statements. Absent, I'm going to open that safe whether you agree to it or not. That a warrant is being authorized and will be processed at any moment. Ms. Franks told the detective she had sensitive medical records in that safe, and the
30
detective
seconds.
found those records when she opened it. Those records didn't become any less private. Ms. Franks just didn't think asserting her rights would do anything for her anymore. Finally, Your Honor, we'd like to note that the prosecution bears the burden in this issue under the authority of Bumper v. North Carolina. For these reasons, we ask that you grant our motion, excluding Exhibit A and any references thereto from today's trial.
Stop.
Thank you.
Thank you, counsel. Is counsel for the prosecution ready to begin?
Yes, Your Honor.
Please summarize your arguments.
Thank you, Your Honor. Good afternoon, Your Honor. Sophie Sperano representing the people. We're moving to admit the notes about the signet ring into evidence as they were obtained lawfully under the Fourth Amendment with the voluntary consent of Jordan Franks. The notes in question were acquired from a safe within Franks' cabin. By the time Detective Mavis had arrived at the cabin, she had already discovered evidence of a ring box in the Blue Diamond Cafe discarded in a trash can. In close location to where she found Franks, she was also told by Cher that Franks had stolen the ring after breaking Cher's arm. As a result of the detective's investigation, she filled out a warrant application and asked Franks to search the room. Franks agreed, which ultimately led to the discovery of a safe. Mavis requested Franks open the safe, to which Franks initially refused, stating, "I know my rights." But after speaking with Detective Mavis, who said a warrant would be authorized, Franks changed her mind and consented to the search. Your Honor, the case U.S. v. Evans is exactly on point.
Tell me about the facts in that case.
Yes, Your Honor. In that case, in U.S. v. Evans, the FBI agent, consent was given after FBI agents told the defendant's father they would obtain a search warrant if consent was not given. May I proceed, Your Honor?
You may. And what's the issue in that case?
Yes, and the issue in this case is whether or not they believed that they had the ability to freely choose against consenting to that search. And Your Honor, in our case, like Evans, the defendant believed that they had that choice. May I proceed, Your Honor?
You may.
Thank you. Now, here too, we see that after Detective Mavis stated that she would in fact obtain a search warrant if consent was not given, and we see that there...
Let me take you back to the Evans case, and I pardon my interruption, okay? I apologize for interrupting you, counsel. The Evans case involved a matter where there was an investigation concerning an auto theft incident, and they responded to the residence where the vehicle was located, I believe in the driveway. They arrested the defendant in that case, or the suspect in that case. The father came out, notwithstanding the admonitions from the officers to stay away. The father nevertheless ignored the admonitions of the officers and went ahead and approached the garage, and then ultimately gave consent for them to search the vehicle. Is that correct?
Yes, it is, Your Honor.
And can you tell me what the holding was on that case?
Yes, Your Honor. The holding was that the consent was valid, and in fact, it was valid as a result of the totality of the circumstances.
Okay, so tell me about the different factors that the court considered there.
Well, Your Honor, in that case, the court considered the fact that the defendant there was aware of the fact that they had a choice to consent or not.
Okay, so then how does that case help you out in this particular matter?
Well, Your Honor, this case shows that, additionally, Franks was not intimidated by Detective Mavis. Franks knew of her right to deny the detective access to that safe. And, Your Honor, Franks chose to unequivocally deny the detective the right to search that safe initially. And after having done that, she changed her mind, choosing to consent to the search of that safe. But, Your Honor, the defendant was not threatened by Detective Mavis. Choosing to refuse the detective the right to search that safe, in fact, showed that she was not threatened by Detective Mavis.
Wasn't the detective persistently and repeatedly requesting over and over and over to give access to search that safe?
Your Honor, I would like to note a discrepancy amongst the statements between Detective Mavis and the defendant, Franks. In Franks' statement, yes, it was stated that there 5 to 6 times Detective Mavis had requested Franks to open that safe. However, in Mavis' statement, Detective Mavis stated that in fact it was in Franks' best interest, and we can infer that this was relating to the surrounding circumstances on that ship. The fact that there were 4,000 other passengers there waiting for this investigation to be concluded, as well as the fact that Franks had an airplane to catch the very next day to New York.
When we talk about the totality of the circumstances in this particular scenario, what are the relevant circumstances?
Well, the relevant circumstances are the defendant's ability to understand the fact that they can, in fact, deny the police the right to search the property.
So you mentioned that Franks understood that she had the right to refuse the request to search, correct?
Yes, Your Honor. The defendant had in fact stated, "I know my rights," to the detective.
All right. In this case, we have an encounter between the detective and Franks that's conducted inside a cabin. Is that correct?
Indeed it is.
In your opinion, would the size of the cabin be relevant to the totality of circumstances analysis in this case?
I would, in fact. And I would say that given the tight quarters of the cabin, I believe 125 square feet, we can see that when Detective Mavis moved away from the defendant after having requested Franks to open that safe, this was simply, as stated in their witness statement, that they were giving the defendant space in order to be less intrusive inside of such a small cabin.
So 125 square feet is extremely tight. Would you agree or disagree?
I would say it is small.
And you have a detective that's standing in the doorway. Is that correct?
Your Honor, the detective moved away from the defendant in order to give them more space.
And after the detective moved away, where did the detective go?
The detective did in fact stand in the doorway.
And how many ways were there to go inside and outside of the cabin?
Just the door.
So the lone point of ingress and egress was the doorway where the detective was standing to block Franks. Is that correct?
Your Honor, again, the defendant was in this tight room and had a choice to make. The detective attempted to give the defendant space in order to think over their choice, and after stating, "I know my rights," they were in fact aware of that choice to consent or to wait for a warrant to be obtained.
Please continue with your argument, counsel.
Thank you, Your Honor. The case, People v. McClure, further illustrates that this is a case of voluntary consent. The court found the defendant's consent was valid, holding that, as law enforcement did not attempt to coerce the defendant into complying. And here too, there was no coercion. Your Honor, the detective's statement that a warrant would be obtained was simply made in good faith, as her findings from her investigation led her to believe the search warrant would in fact be authorized.
2 minutes.
And Your Honor, the defendant in McClure was in custody when he gave consent. Here, Franks was not under arrest while being interviewed by Detective Mavis. No improper assertion of police authority was made, and Franks wasn't under arrest nor in handcuffs. Given the totality of the circumstances, including Franks' statement that she knew her rights, Your Honor, consent was given voluntarily.
Counsel, pardon the interruption. You make reference to the McClure case. Do you find that the McClure case factually is similar to the circumstances here, or is it distinguishable?
Well, Your Honor, I find that the fact is factually similar in the fact that the defendant there was in fact given the choice to comply or to wait for that search warrant.
Was a choice given in this case?
Yes, Your Honor, I would say that a choice was given. Firstly, in stating that I know my rights, Franks was aware of her choice to consent or wait for that warrant to be obtained. And in fact, by stating and asking the defendant to search that safe, she was also given a choice by the detective.
And I'm going to be paraphrasing here, but didn't the detective say, I'm going to get into that safe whether you agree or not?
Your Honor, the statement that a warrant would be obtained if consent is not given is a simple declaration of the legal remedy available to an officer if consent is not given.
And which case supports that proposition there?
I'm glad you asked. The case People v. Ratliff.
Tell me about the Ratliff case.
Yes, Your Honor. In examining the case People v. Ratliff, the court will see that the defendant there was first under greater stress than in our case, having been awoken by officers with their guns drawn on him. And yet, the court still found that the consent was valid, holding that telling a defendant that a warrant would be obtained if consent was not given was again a simple declaration of the legal remedy available to the officer if consent is not given.
So to be clear, on the Ratliff case, officers went into the home of a suspect, they woke him up, startled him, and then guns were drawn?
Yes.
So they held that individual at gunpoint?
They did indeed.
And ultimately the court declared and held that consent was voluntary in that particular case, notwithstanding those particular factors?
Yes, they did.
All right, please continue with your argument.
Thank you, Your Honor. And again, when Mavis stated that a warrant would be obtained if consent was not given, like the case People v. Ratliff, this was a simple declaration of the legal remedy that the detective reasonably believed would come to the aid of her investigation. Franks willingly agreed to the search and let Detective Mavis into that safe. Your Honor, unlike the case in People v. Ratliff, where consent was still considered valid, Franks was not placed in handcuffs.
1 minute.
Franks was not under arrest. Franks was aware and knew of her right to deny the detective access to anything in the room, which she initially chose to exercise. Your Honor, Franks showed no apprehension as a result of Detective Mavis's actions, and the detective acted in accordance with the law, deeming consent voluntary. The law is clear. As such, the notes about the signet ring should in fact be admitted into evidence. Thank you, Your Honor.
Thank you, counsel. Does the defense have a rebuttal?
Yes, Your Honor.
Please proceed.
Your Honor, first I'd like to invite the court's attention to page 28, line 2. This is the case of People v. Ratliff, where it states in the holding, the police no longer had their guns drawn when they began questioning the defendant. I'd also like to address the discrepancy opposing counsel mentioned between Ms. Franks' statement and Detective Mavis's. They insinuated that because it was different, it's somehow not as credible. But Your Honor, there's no indication. The prosecution have brought no evidence suggesting any of Ms. Franks' statements are not credible. And as they bear the burden, it's not reasonable for the court to assume such. Your Honor, we'd also like to distinguish the cases of Evans and McClure. To be clear, Detective Mavis never said, I will obtain a search warrant if you don't consent. Detective Mavis never offered Ms. Franks a choice. A warrant was never mentioned in any context other than the fact that it was already being authorized, and that fact is not in dispute in any way. This clearly sets our case, apart from the cases of Evans and McClure. In Evans, opposing counsel also argued that Ms. Franks was similarly unintimidated.
30 seconds.
But she said, I was scared of the detective's attitude, talking to me as if I was in a criminal. as if I was a criminal. She was scared. She was intimidated, and she showed that. Your Honor, Ms. Franks only opened that safe because of the detective's coercion. We ask that you grant our motion excluding Exhibit A. Thank you.
Thank you, counsel. Does the prosecution have a rebuttal?
Yes, Your Honor. May I proceed?
You may.
Thank you. Your Honor, the defense has attempted to convince you that the defendant was coerced, detained, and threatened. However, in the case that the defense counsel mentioned, Schneckloff v. Bustamante, this case examines the issue of whether consent is valid looking at the totality of the circumstances, specifically of the defendant's awareness of their ability to refuse a search. And here, Frank said, "I know my rights." She wasn't detained, and she was not intimidated by Detective Mavis. Additionally, in the case Bumper v. North Carolina, this case is completely factually distinguishable from our case, as a result of the fact that in Bumper, they had a search warrant. They stated they had a search warrant when they in fact did not. Here, Detective Mavis simply stated that a warrant would be authorized, which Detective Mavis had in fact begun the authorization process, having completely filled out a warrant application even before she had arrived at Frank's cabin.
Did the detective say that the warrant was already being authorized?
Yes. No, Your Honor, they said that warrant would be authorized. May I proceed?
You may.
Thank you. Additionally, the defense states the case Hicks, which, unlike Hicks, Detective Mavis was aware of the facts at hand, and in that case, a primary officer said that they in fact had probable cause to acquire a warrant when they did not, and was told that they had probable cause by a secondary officer, and consent was deemed invalid. However, here, Detective Mavis knew of the entirety of the fact pattern and was well aware of the facts at hand. And again, Franks stated, "I know my rights." Franks was aware of her right to deny the detective that search and yet consented. Your Honor, with this, we respectfully request that you grant the contents of the safe into evidence. Thank you.
Thank you, counsel. Counsel for the defense, are you requesting to confer with your attorney or teacher regarding any irregularities?
No, Your Honor, there are no irregularities from the defense.
Counsel for the prosecution, are you requesting to confer with your attorney, teacher, coach regarding any irregularities?
No, Your Honor.
All right, so at this point in time, the court has considered the arguments of counsel. The court has read and reviewed the statutory authority, the constitutional authority, and also the decisional authority that has been provided to the court, that has been argued also by counsel. At this point in time, based on the statutory and decisional authority that the court has reviewed, and based on the evaluation of the totality of circumstances in this particular case, the court finds that in this particular matter, that the consent was voluntarily given, there was no coercion, and at this point in time, the motion from the defense is respectfully denied. So the exhibit and the subsequent evidence that was derived from the search of the safe, that will be allowed to be admitted into evidence at this time. Is everyone prepared to proceed with the trial at this point in time?
Your Honor, we request permission to rearrange.
That is granted.
And additionally, we'd like to note that by denying the motion, it's allowing the offering of Exhibit A, but it doesn't necessarily admit it at this time, Your Honor.
Understood and duly noted, counsel.
Yes, Your Honor.
All right, so at this point in time, prosecution, do you have any physical evidence that you would like to present for inspection?
Yes, Your Honor. At this time, the prosecution would like to submit Exhibit A, which is the notes found in the safe containing information about the signet ring. Additionally, the prosecution would like to submit Exhibit B, which will denote the signet ring offered in court today. Additionally, the prosecution would like to submit Exhibit C, which is the velvet ring box that held the signet ring. Thank you.
And does the defense have any physical evidence that it would like to present for inspection?
Yes, Your Honor. In addition to the exhibits that opposing counsel brought up, we have exhibits A through E, including some of those exhibits that we ask be placed on the witness stand and has been pre-approved by opposing counsel.
That request is granted, so please hand those to our bailiff.
In addition, Your Honor, the defense has some preliminary matters to take up.
All right, please proceed.
We ask that all witnesses be constructively sequestered, barring the defendant.
I'm sorry, say that again.
We ask that all witnesses be constructively sequestered for the purposes of a mock trial, barring the defendant, Jordan Franks.
Any objection?
No, Your Honor.
All right, that request is granted.
Yes, Your Honor. In addition, we ask as to your preference as to approaching witnesses.
That request is granted. As far as coming up, just feel free to walk up. You do not need to ask me for my permission. Don't ask for any request to approach. You just simply approach whenever you need to approach. Understood?
Yes, Your Honor.
All right.
With that, the defense is ready to proceed.
Okay. And any other requests from the people?
No, Your Honor, not at this time.
All right, so in this matter, the people of the state of California are charging the defendant, Jordan Franks, with robbery and battery of Franks' fellow actor, Billy Shear. Prosecution, are you ready to present opening statements?
Yes, Your Honor.
All right, please proceed.
Thank you. On June 9th, 2021, the defendant, Jordan Franks, broke in the shadow of their roommate and co-star, Jordan Frank, or Billy Shear. They would go to proceed and say the words, "You don't deserve the role or the ring. How could you do this to me?" And finally, Jordan Franks would say, "Get out of my way." These are all manifestations of Jordan Franks' fervent obsession with Billy Shear and Billy Shear's signet ring. You see, as roommates and co-stars above Heart of the Ocean, and also, my apologies, and also considering the fact that Jordan Franks never got the dream role, never got the dream ring, and never got the, never got the recognition they would bring. Tonight, Jordan Franks is charged with battery, robbery, and grand theft. You will hear from 4 witnesses tonight. First comes Billy Shear. Billy Shear will testify to the tumultuous relationship aboard Heart of the Ocean. They will talk about how Jordan Franks constantly would make horrendous remarks towards them, among other cast members. Next, you will hear from Cleo Schaefer, who gifted Billy Shear the signet ring. Cleo Schaefer as well will testify to the fact that Jordan Franks was obsessed. Furthermore, Cleo Schaefer will see Jordan Franks in the Blue Diamond Cafe throwing something away in the trash after the altercation had ensued. Third, you will hear from Ari Couch, our expert witness tonight. Ari Couch, a decorated archaeologist and gemologist, will talk about the historical parallels about the ring presented in the court tonight, as well as the parallels shared with William Shakespeare's ring himself. Lastly, you will hear from Detective Mavis, the detective aboard the ship. Detective Mavis will talk about finding a piece of paper in Jordan Franks' safe, denoting the value of the ring, the number to a courthouse, as well as finding the signet ring in Jordan Franks' own costume pocket. Your Honor, tonight the defense will downplay everything that has the totality of the evidence, but truthfully, Your Honor, there is no one of the 4,000 members of Heart of the Ocean that knew Billy Shear as intimately as they did. There is no one with the unique combination of motive, knowledge, and opportunity other than that signet ring that was served upon a silver platter that evening in that cabin. Your Honor, the people would like you to keep in mind the fact that tonight, Jordan Franks is the person who injured Billy Shear and stole the ring. Thank you.
Thank you, counsel. And is the defense ready to present the opening statement?
Yes, Your Honor.
Please proceed.
Sophia Cho for the defense. May it please the court. It's June 9th, 2022, and the final performance of Macbeth at Sea has just ended. The 2 leads, Jordan Franks and Billy Shear, are arguing backstage. Your Honor, it's nothing new. The 2 do not get along. Afterward, Mr. Cher goes back to his cabin, one he's shared with Miss Franks for 3 long years. Tomorrow, Miss Franks is going to follow him to New York City to be his understudy in a Broadway play. Mr. Cher is fed up. He can't take it anymore. So he hatches a plan. Stage a robbery and frame Miss Franks. On his way to the cast wrap party, he places his signet ring in Miss Franks' costume, then throws out its ring box at the Blue Diamond Cafe. At midnight, he returns to his cabin, accuses Miss Franks of stealing his ring, and tries to block her as she leaves. Your Honor, it was all a setup. The play had ended, but the acting hadn't. Nevertheless, the prosecution has charged Miss Franks with robbery and battery resulting in serious bodily injury. They must prove each element of their case beyond a reasonable doubt. But, Your Honor, you'll learn that Mr. Cher had the means, the motive, and the opportunity to stage the entire thing. And that is reasonable doubt. You'll hear from 4 witnesses today. First, Jade Marquez will call into question the prosecution expert's appraisal of the ring in today's case. You'll learn there is simply no way of knowing whether this ring truly belonged to Shakespeare. After that, Ezra Weintraub, the ship's head of security, will tell you just how superficial the police investigation was. That there was camera footage, once available, that could tell us what happened that night. Simply that the police asked too late. After that, Carter Lucky will tell you about the altercation that he witnessed between Miss Franks and Mr. Cher. Your Honor, he was clear in what he saw. Miss Franks did not push Mr. Cher to the ground. Finally, you'll meet Miss Franks. You'll learn what she did, where she went on the night of June 9th. Above all, she'll tell you she did not, would not steal Billy Cher's ring, and will tell you what she's been saying this entire time. She is being framed. Your Honor, the play had ended, but the acting hadn't. At the end of today's trial, we'll ask that you find Miss Franks not guilty. Thank you.
Thank you, counsel. Prosecution, you may call your first witness.
Calling Billy Cher to the stand.
Billy Cher. Are you able to raise your right hand?
I'm not.
It's okay. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
You may be seated. Your Honor, I'd like to note that per Rule 3.10R, this witness is sworn in despite his inability to raise his right arm.
Understood and duly noted for the record. Thank you.
Please state your name, spelling your last for the record.
Billy Cher, S-C-H-E-R.
What is your name?
My name is Billy Cher.
Could you summarize your education for the court?
I have a bachelor's degree in the dramatic arts.
Where do you work?
I work aboard the cruise ship, the Heart of the Ocean.
For how long?
About 3 years.
Did you star in any plays aboard this ship?
Yes, I starred in Macbeth at Sea.
Did you enjoy Shakespeare?
I love Shakespeare.
So when you were starring in Macbeth, did you live on board the ship?
Oh yes, I lived in a cabin.
Did you share a cabin with anyone?
I shared the cabin with my co-star, Jordan Franks.
How big was your cabin?
It was quite small. We had bunk beds.
So where did you typically keep your valuables?
We kept our valuables in safes in the cabin's closets.
Did you often use your safe?
Yes.
Why?
Well, I have a signet ring once owned by William Shakespeare. It's a priceless artifact, so I like to keep it safe.
Showing you it has been marked as Exhibit B. Do you recognize this?
Yes.
Is this that ring?
That is.
Is this a fair and accurate representation of that ring?
Yes, it is.
Your Honor, the people request to move Exhibit B into evidence.
Any objection?
No objection, Your Honor.
Exhibit B is admitted into evidence.
When did you obtain this ring?
My good friend Cleo Schaefer gave it to me in April 2022.
How often would you wear this ring?
I wore that ring every day, and I wore it to every performance of Macbeth at Sea.
And in your personal opinion, what is the value of this ring?
To me, the ring's priceless, but I believe it's been estimated at around $170,000, something like that.
Your Honor, objection? Lack of foundation?
Your response, counsel?
Your Honor, as Billy Scher previously testified, he is the owner of this property, and a property owner has the right to testify towards something's value according to the mock trial rulebook.
The objection is overruled. Next question.
Moving on to your roommate, Jordan Franks, how would you describe your relationship?
We've never really been on great terms, but it went pretty bad on June 9th.
Why is that?
Well, after Macbeth at Sea ended on June 9th, Franks just blew up at me right after the curtain dropped.
Blew up at you?
Yes, she started accusing me of changing lines to make her look bad.
Was there anyone around who witnessed it?
Yes, Cleo Schaefer saw it and other cast members.
How did you respond?
I was really shocked. I didn't know what to do. Before I could really say anything or defend myself, Schaefer stepped in, and I took the opportunity to go back to my room to prepare for the wrap-up party that night.
Was this the first time you'd experienced tension with Jordan Franks?
No, as I said, we've never really had the greatest relationship. I'd always hear about her talking behind my back, about how I only got this role because of my relationships to the casting directors, and then finally also comments about my ring and its worth and how I should never have gotten it.
After this encounter, then what did you do?
I went to my room to prepare for the wrap-up party later that night.
When you got to your cabin, then what did you do?
I took my ring off and put it in its ring box. I set the ring box on the dresser next to my table. Next to my bed, sorry.
Did you go to the cast party?
I did.
Who else was at the cast party?
Cleo Schaefer and some other cast members.
Were you wearing your ring?
I was not.
Was Jordan Franks at the cast party?
Yes, she was.
Did you speak with Jordan Franks?
I did not.
How long were you at the cast party?
About 3 hours.
What time did you leave?
Around 12 a.m.
Did you go back to your cabin?
I did.
Did anything happen when you got back to your cabin?
Yes.
Describe to the court what happened.
Well, when I got to my cabin and opened the door, the first thing I noticed was the lights were off, but I could still see thanks to the hallway lights as the door was open behind me. I noticed Jordan Franks standing next to my bedside table. She looked really startled to see me.
Your Honor, objection? Speculation?
Your response?
It's in the witness statement that Mr. Scher noticed that Jordan Franks was startled when he opened the door.
Any final comment?
Yes, Your Honor. Just because the witness states that in his witness statement does not mean that it is not speculative as to what he observed.
I'll sustain the objection.
Your Honor, I ask that the answer be stricken.
That request is granted. Next question.
What else did you observe?
I observed that Jordan Franks had my ring box in his hand.
The ring box that normally held your William Shakespeare ring?
Yes.
Your Honor, objection? Leading?
Overruled.
Then what happened?
Well, I was so surprised. I yelled at Jordan Franks, "Give me back my ring!"
Objection? Hearsay?
Your response?
Thus far, Mr. Scher is testifying to his own statement.
The objection is overruled. Next question.
Then what happened?
Then, instead of putting the ring down or talking to me, Jordan Franks started to approach me and started yelling, "How could you do this to me? You don't deserve the role or the ring."
How are you feeling?
I was scared. I didn't know what she was trying to do. I didn't know if she was going to attack me or anything.
Then what happened?
Right as she got right in front of me, she yelled at me, "Get out of my way!" And then with all her might, pushed me to the side.
What did you do after that?
I fell and hit my arm on the bed. As I tried to get up, I felt intense pain in my arm. As I rolled over, partly in shock, I saw Jordan Franks run out of our cabin, having stolen my ring box.
Then what happened?
I crawled over to the cabin phone to dial 911 to report the robbery.
What time was it when you called 911?
About 12:30 a.m.
Did you speak with any police that night?
Yes, I spoke to Detective Mavis when she arrived with the paramedics.
Did you get any medical attention for your arm?
Yes, I had broken my arm in 2 places, the ulna and the radius.
Has that injury affected your career in any way?
Yes.
How?
Well, earlier on June 9th, I had learned that I had gotten a role that I had wanted in the Broadway play, Jefferson the Musical. Because of this injury, I lost that role.
Can you tell the court who was your understudy for that part?
Jordan Franks.
So would Jordan Franks would have gotten the role?
Yes.
Is Jordan Franks in the courtroom today?
Yes.
Can you point her out, please?
The lady in blue. That is my roommate. That is Jordan Franks.
Your Honor, would the record reflect that the witness has identified the defendant?
So noted for the record.
Thank you. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Your Honor, may I proceed?
You may.
Good afternoon, Mr. Sheriff.
Good afternoon.
I'd like to talk with you about June 9th, 2022.
Okay.
After the final performance of Macbeth at Sea, you say that Miss Franks accosted you?
She began to argue with me after this curtain dropped.
After that, you went back to your cabin, right?
Correct. I went back to get ready for the wrap-up party that Schaefer was hosting.
You took off your ring?
I took off my ring.
You put it in your ring box?
That's right.
And you left that ring box on your dresser?
Correct. I put that on the dresser right next to my bedside table.
And like you said on direct examination, there's a safe in your room?
Correct.
You didn't put that ring box in your safe?
No. I was in a rush to get to the wrap-up party, so it's just more convenient for me.
I'd like to talk about the route that you took to get to that wrap party. If you could please direct your attention to Exhibit D in the binder in front of you. Please let me know when you get there.
I've got it.
This is a fair and accurate depiction of the Heart of the Ocean's layout as it was on June 9th.
I believe so, yes.
You recognize the layout of this ship?
Yes.
Your Honor, at this time, the defense would like to move Exhibit D into evidence.
Any objection?
No objections, Your Honor.
Exhibit D is admitted into evidence at this time.
Now, Mr. Sheriff, the cabin that you share with Miss Franks is on Deck 2?
That's correct. Crew deck.
The Midnight Lounge is on Deck 8.
That's right.
So, to get from Deck 2 to Deck 8, you'd have to walk through Deck 7?
That's correct.
Deck 7 is where the cast dressing room is?
That's right.
And to walk to the Midnight Lounge, you'd have to walk through Deck 8?
I would have to cross through it, yes.
Objection, relevance. Why is it relevant where Billy Shear has to walk?
Speaking objections, so just state the legal basis. Understood, counsel? And what's the legal basis again?
Why is it
relevance?
Relevance.
Your response, counsel?
Yes, Your Honor. It's the defense's contention that based on this map, Billy Shear had the opportunity needed to plant the ring and frame our client. This goes to the heart of the defense's case.
The objection is overruled.
To walk the Midnight Lounge, you have to go through Deck 8?
That's correct.
Deck 8 is where the Blue Diamond Cafe is?
Yes.
Now, after the party, you went back to your cabin, right?
That's correct.
You got there at around 12:15?
12:30.
Now, you say in your statement that you left the party at around midnight, right?
That's right.
And it's stipulated, too, that it takes about 15 minutes to walk from Deck 8 to Deck 2. Do I have that right?
I believe so.
And as a witness testifying today, it's your duty to be aware of all the relevant stipulations.
That's right.
So you got back to your cabin at 12:15 in the morning.
Perhaps. I might be a little fuzzy on my memory.
Now,
Sure.
An altercation between you and Miss Franks ensued?
That's right.
That happened pretty fast, didn't it?
You could say so, yes.
Mr. Sherry, you didn't call 911 until 12:30.
Correct.
Thank you, Your Honor. I have nothing further.
Would the prosecution like to redirect?
No, Your Honor. May this witness be excused?
Counsel, may the witness be excused?
Your Honor, this is not my witness and no recross is allowed.
Okay. So, yes is the answer. This gentleman may be excused, so thank you for your testimony. You are excused. The people's next witness.
At this time, the people would like to call Cleo Schaefer to the stand.
Cleo Schaefer, please proceed to the witness stand. Stop and face me. Raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? I do. You may be seated. Please state your full name, spelling your last for the record.
Cleo Schaefer, Schaeffer.
May I proceed, Your Honor?
You may.
Good evening, Ms. Schaefer. May you please state your name to the court?
Good evening, I'm Cleo Schaefer.
Now, what do you do for a living?
I'm retired, being that I'm in my 70s.
And where do you live?
Heart of the Ocean.
And are you aware of Macbeth at Sea?
Yes, I'm a benefactor of it.
You said benefactor?
Yes.
Now, as a benefactor, are you aware of any of the cast and crew above the production?
Yes, Billy Scher.
And how do you know Billy Scher specifically?
I went to school with Billy Scher's grandmother, and so we're close family friends. I regard them. I see them as like a child of mine.
Child of yours?
Yes.
Now, am I to understand that you gave Billy Scher a signet ring?
That is correct, in April.
And why did you do so?
Well, I believe that they deserved it. It's a priceless ring and a family heirloom, and I have no heirs of my own.
Priceless, you say?
Yes.
Why is it priceless?
Well, I wouldn't sell it to anyone for any amount of money. It's a family heirloom.
Now, moving on. As a benefactor, are you aware of any relationships held above Macbeth at Sea?
Yes, I am, and there seem to be some hostile dynamics.
Hostile dynamics? Between who?
Between Billy Scher and Jordan Franks in particular.
And why do you say so?
Well, on several occasions I would hear Jordan Franks mention how he believes Billy Scher gets special treatment and that they don't deserve the role or the ring.
They don't deserve the role or the ring?
No.
Now, moving on. You threw a cast party on June 9th for the closing of the play, isn't that true?
Yes, that's correct.
And did all the cast attend?
Yes, they did.
So Jordan Franks was there?
Yes.
Objection leading.
Overruled.
Now, at the party, did you hear any or did you notice anything at the cast party?
Well, I saw Jordan Franks and Carter Lackey speaking.
And did you hear their conversation?
Well, I heard Jordan Franks mention how he hopes that Billy Scher would break his leg because then someone competent could take his place.
They said that?
Yes, they did.
Now, what time did you leave the party?
Around 10:45.
And why did you do so?
Well, I was feeling a little tired.
And after you left, where did you go?
I went to my room for a little bit, and then I decided I wanted a little snack from the Blue Diamond Cafe.
And at the Blue Diamond Cafe, did you notice anything significant?
Yes, I saw Jordan Franks throw something away in the trash.
Throw something away in the trash?
That's correct.
Now, did you notice anything after that?
I saw Jordan Franks and Carter Lucky speaking at one of the tables.
And did you interact with them at all?
No, they seemed to be having a deep conversation.
Thank you. No further questions.
Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Schaefer.
Good afternoon.
Now, you just testified on direct examination to hearing Ms. Franks say you don't deserve the role or the ring. Do I have that right?
Well, yes.
You didn't mention that anywhere in your witness statement.
I recall mentioning them say that they believed that that Billy Scher didn't deserve it.
Ms. Schaefer, you didn't mention that anywhere in your witness statement.
Well, I apologize if I didn't, but I believe that I did mention that.
Ms. Schaefer, is that a yes to my question?
I suppose.
Now, I'd like to talk about your relationship with Billy Scher. The two of you are quite close.
Yes, as I said in my direct, I see Billy Scher as like a son of mine.
You also know someone named Jordan Franks.
That is correct, I do.
You're quite close. Or you don't like Miss Franks, do you?
Well, I don't have any strong bad feelings towards them.
You think that Miss Franks is jealous of Mr. Scher?
Well, I mean, jealousy is quite common, and they did mention once that they believe that Scher got special treatment.
I'm not asking about that. You think that Miss Franks is jealous of Mr. Scher?
Well, I suppose, yes.
You testified on direct examination to hearing a statement about breaking a leg. Do I have that right?
Yes, so then someone competent could take their place.
You overheard this conversation, Ms. Schaefer.
At my cast party, yes, I did.
You weren't a part of it.
Well, no, but I could hear them. I was close by.
You didn't ask Ms. Franks what she meant by it.
Well, I didn't feel there was a need to.
Is that a yes to my question?
No, yes, I didn't ask them about it.
Afterward, you went back to your cabin.
That is correct.
Now, you also testified to seeing Miss Franks throw something away at the Blue Diamond Cafe. Do I have that right?
Yes, that's correct.
I'd like to turn your attention to what's been marked for identification as Exhibit C in the binder in front of you.
Oh, yes.
You recognize this?
Yes, that's the ring box.
This is the ring box that was in your family for generations.
Yes, it was a family heirloom, as I mentioned.
You'd recognize this ring box if you saw it.
Yes, I would.
You can't tell the court this is what you saw Miss Franks throwing out that night.
I didn't look at the trash. I didn't look inside the trash can, so I'm not sure what they threw out.
Is that a yes to my question?
Yes, I don't know what they threw out.
Thank you, Ms. Schaefer. Your Honor, I have nothing further at this time.
Any redirect examination?
Yes, Your Honor. Just to clarify, in your witness statement, Ms. Schaefer, you did say that you heard Jordan Franks saying that Billy Scher didn't deserve the lead role or the ring. Isn't that true?
Yes, that is true.
Thank you. No further questions.
All right, so at this time, you're requesting to have this witness excused, is that correct?
Yes, Your Honor.
All right. Thank you for your testimony. You are excused. And the people's next witness?
Your Honor, prior to the people calling their next witness, the defense would like to request a time check on behalf of both parties.
The request is granted.
The prosecution has 5 minutes and 59 seconds left on direct, and the defense has 4 minutes and 16 seconds left on cross.
Thank you, Mr. Clerk.
Any other requests, counsel? No other requests from defense counsel?
No other requests, Your Honor.
All right, please call your next witness.
Calling Ari Couch to the stand.
Ari Couch, please proceed to the witness stand. Stop and face me. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
You may be seated. Please state your full name, spelling your last for the record.
Ari Couch, Kouch.
May I proceed?
You may.
What is your name?
Ari Couch.
And what is your occupation?
I'm a certified jury appraiser.
What entity certifies you?
I'm certified by both the American and French Association.
Could you summarize your educational background for the court?
Sure. I majored in archaeology at the Oxford University. I then completed the graduate gemologist program at the Gemological Institute of America.
And as a graduate student, did you specialize in any specific areas?
Yes, I focus on the 15th and 16th century jewelry.
Ms. Couch, are you prepared to testify today about your opinions regarding the authenticity of a signet ring owned by Billy Scher?
Yes, I am.
Please tell the court your opinion.
The signet ring owned by Billy Scher was once owned by William Shakespeare in the late 1500s.
What is your opinion based upon?
Well, I first reviewed the supporting paper provided by Cleo Schaefer. Second, there's a strong historical evidence that I am familiar with.
Let's examine that historical evidence. Could you list that evidence for the court, please?
Sure. First, I'm familiar with William Shakespeare's last will and testament in which he left the signet ring to a distant relative of Cleo Schaefer. Second, the ring was examined by the Royal Academy of Arts in 1780 and was certified to have belonged to Shakespeare. Third, the ring bears the initial WS, and as an archaeologist, I can say that the ring has a distinct Elizabethan style. Fourth, the ring's size and style are consistent with the Elizabethan era. Fifth, the ring has been displayed at the Royal Academy of Arts for over 100 years long. And finally, the ring was shown in a large portrait of William Shakespeare from the early 1600s and now hangs at the Shakespeare Birthplace Trust.
Now, did this ring disappear for a period of time?
Yes, and it was rediscovered in 1780.
Did you take that into account in forming your opinion?
Yes, and it doesn't change my opinion. When the ring was rediscovered, it was discovered at a place that was frequently visited by Shakespeare.
Showing what you has been marked as Exhibit B, do you recognize this?
Yes, this is the signet ring that was asked to appraise.
And it is your opinion that this ring was once owned by the William Shakespeare?
Yes.
One last question, Ms. Couch. What is your opinion on the value of this ring?
Well, this ring weighs 14 grams and is made of gold. Given the historical connection with William Shakespeare, I appraise the ring at being worth $170,000.
Thank you. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor.
Your Honor, may I proceed?
You may.
Good afternoon, Ms. Couch.
Good afternoon.
I'd like to talk a little bit about the provenance papers that you examined. Now, like you said on direct examination, there's a gap in documentation as to the location of Shakespeare's ring.
Yes, and just as I mentioned in the direct, it was found at a place that was frequently visited by Shakespeare, and I do assume that the disappearance of the signet ring does not affect its own value and who it was once owned.
I'm not asking you about that, Miss Couch.
Okay.
The ring disappeared in the late 1500s?
Yes.
And unlike what you said on direct examination, it was rediscovered in 1769.
Yes. At the Stratford?
I want to be clear. On direct examination, you said that the ring was in the possession of a distant relative of Cleo Schaefer.
Yes.
You said that John Hemmings and William Schaefer were related?
Well, they were distant relatives.
But you provide no evidence as to how you came to that conclusion.
Well, I believe that was their own family business, but even if they weren't, I assume, it doesn't change the value of the ring.
Ms. Couch, I'm not asking you about that. You have no evidence that John Hemmings and William Schaefer were related?
Yes. I mean, I don't.
You don't mention that evidence anywhere in your report?
Yes.
You do mention evidence of that in your report?
No, I just don't found how that is relevant.
I'm not asking if you find it relevant.
Mm-hmm.
You have no direct evidence that the person who received William Shakespeare's ring is related to Cleo Schaefer?
No.
Thank you, Ms. Couch. Your Honor, I have nothing.
Redirect examination?
No, Your Honor. May this witness be excused?
Yes. Thank you for your testimony. You are now excused. And the people's next witness?
At this point, Your Honor, the people would like to call Dylan Mavis to the stand.
Dylan Mavis, please proceed to the witness stand. Please stop and face me. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? I do. You may be seated. Please state your full name, spelling your last for the record.
Dylan Mavis, M-A-V-I-S.
May I proceed, Your Honor?
You may.
Good evening, Miss Mavis. May you please address yourself to the court?
I'm Dylan Mavis, the lead detective at the Portsmouth Police Department.
And were you working on the early morning hours of June 10th?
I was.
Where were you?
I was at the heart of the ocean.
And at what time did you arrive on the ship?
Around 1 a.m.
Now, what did you first do when you arrived?
I spoke with Billy Scher.
And were you two alone?
No, the paramedics were there as well.
And why were the paramedics there?
Scher had injured his arm in an altercation.
And how did Billy Scher seem to you?
Scher was in a substantial amount of pain, but also aggravated and upset.
And you were able to communicate with them, correct?
Yes.
What did they tell you?
They told me about the altercation between them and their roommate, Franks.
Did they say anything else?
They said they walked into their room around midnight and saw Franks holding their ring box. They thought the ring was in it and asked for it back.
Objection, hearsay.
Your Honor, this falls under an excited utterance. Dylan Mavis just testified to the fact that an altercation ensued and the fact that Billy Scher had suffered a significant injury.
Any final comment, defense counsel?
Yes, Your Honor. The excited utterance exception per page 73, line 23 reads a statement that describes or explains an event perceived by the declarant. Billy Scher explaining what had just happened doesn't describe or explain an event perceived by the declarant made during or shortly after starting an event while the declarant is still under the stress of excitement caused by that event.
I'll overrule the objection.
Moving on. After you spoke with Billy Scher, who did you speak to next?
I spoke with Carter Lucky and Cleo Schaefer.
Now, did you ever make contact with Jordan Franks that evening?
Yes, I did.
Where did you find him?
In the Blue Diamond Cafe.
And before approaching Jordan Franks, did you observe anything significant?
Well, I scanned the room for evidence and I found a black velvet ring box inside a trash can.
And did you collect it as evidence?
Yes, I did.
Showing you what has been marked as Exhibit C, do you recognize this?
Yes.
What is it?
It is the black velvet ring box.
2 minutes.
And is this a fair and accurate description of what you found?
Yes.
All right. Moving on. Did you interact with Jordan Franks?
Yes, I introduced myself to him.
And did you guys speak?
Yes.
What did Jordan Franks tell you?
Franks told me that they did not know anything about the ring box.
And did Jordan Franks speak with you about the altercation that had ensued?
Yes, they told me a different side of the story.
Now, moving on, did you... Apologies. After you conversed with Franks, did you conduct a search?
Yes, I asked Franks to search their cabin.
And did they comply?
Yes, but they did not let me search a safe.
Did they eventually comply?
Yes.
And what did you find?
Inside, I found some medical documents that I set aside, and then I also found a piece of paper.
A piece of paper, you say?
Yes, on the piece of paper there was a phone number, some information about a signet ring, and dollar bills signs.
Pointing to what has been marked as Exhibit A, do you recognize that?
Yes, this is the piece of paper.
And is it a fair and accurate description of what you found in the safe?
Yes.
Now, did you ever find the missing ring?
Yes, I found it inside Frank's costume coat pocket.
Their costume coat pocket?
Objection, lack of foundation.
Your response?
Your Honor, the detective testified to conducting a search, and I'm asking whether or not they found the ring because that is the object of interest of both parties.
May I be heard, Your Honor?
You may.
I'm not objecting to the relevance of it, just the lack of foundation as to this being Miss Franks' costume. Opposing counsel has laid no foundation as to that.
May lay foundation, Your Honor.
The objection is sustained. Next question.
A move to strike.
That request is granted.
Moving on, did you speak to anyone else that night?
Yes, I spoke to Ezra Weintraub.
And did you ever show the signet ring to Jordan Franks?
Yes, I showed it to Jordan Franks and they recognized.
Thank you. No further questions.
Cross-examination?
Yes, Your Honor. May I proceed, Your Honor?
You may.
Good afternoon, detectives. Now, I'd like to walk through your investigation. When you first arrived on board, you spoke with Mr. Billy Scher.
Yes.
Billy Scher gave you his version of events.
Yes.
From that point on, Miss Franks was your primary suspect.
I took both versions of events, and yes, that led me to think that Franks was the primary suspect.
2 minutes.
You eventually found Miss Franks.
Yes.
At the Blue Diamond Cafe, as you testified to.
Yes.
Now, while there, you discovered a black ring box.
I did, in the trash can near Frank's.
This was sitting on top of the trash.
Yes.
This was out in the open.
Sure.
Now, you asked Miss Franks about this ring box.
Mm-hmm.
Now, on direct examination...
Pardon the interruption. Is that a yes or a no?
Yes, I apologize.
On direct examination, you testified that Miss Franks didn't know anything about this ring box. Do I have that right?
Franks recognized the ring box as Cher's ring box.
Right. Miss Franks told you it was Mr. Scher's ring box.
Yes.
And afterward, you asked to go back to Miss Franks' cabin?
Yes.
She complied.
Yes. However, she was hesitant about the safe.
I'm not asking about that, Detective. She complied to go back to the cabin.
Yes.
And while there, she let you search her cabin.
Yes, but the safe.
Detective, I'm not asking about that.
Okay.
She let you search her cabin.
Yes.
Now, during the course of your investigation, she told you that she had been grabbing her cell phone during the altercation with Mr. Scher. Do I have that right?
I did not testify to that, but yes.
Detective, Miss Franks told you that she had been grabbing her cell phone. Do I have that right?
That's yes.
Miss Franks owns a cell phone.
Sure, yes. Most people do.
Detective, Miss Franks owns a cell phone.
Yes. I said yes.
I'd like to talk with you about the timeline of your investigation. There was some urgency to it, wasn't there?
Not necessarily. I told the ship to not leave the port, but sure, that could be seen as some time constraint, but not really.
Well, Detective, 7 hours after arriving on board, you arrested Miss Franks.
Well, the totality of the evidence pointed to Franks.
Objection, non-responsive.
That's sustained. Please answer the question.
Okay.
Detective, 7 hours after arriving on board, you arrested Miss Franks.
Yes.
Thank you. Your Honor, I have nothing further.
Any redirect examination?
Yes, Your Honor. After presenting the ring to Jordan Franks, what did Jordan Franks say?
Objection outside the scope of cross-examination.
Withdrawn, Your Honor. Thank you. No further questions.
All right. Thank you for your testimony. You are excused. Any additional witnesses on behalf of the prosecution?
No, Your Honor. At this time, though, the prosecution would like to move Exhibit A into evidence.
Any objection?
None to A, Your Honor.
All right. So Exhibit A is admitted into evidence at this time?
Yes, and at this point, the prosecution rests.
All right. Is the defense ready to proceed with their case?
Yes, Your Honor. The defense calls Jade Marquez.
Jade Marquez. Please proceed to the witness stand. Please stop and face me. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
You may be seated. Please state your full name, spelling your last for the record.
Jade Marquez, Marquez.
Your Honor, may I proceed?
You may.
Good afternoon, Ms. Marquez.
Good afternoon.
What do you do for a living?
I own a jewelry appraisal firm and auction house. I specialize in appraising jewelry for more high-end clients.
How are you qualified for that line of work?
I have over 40 years of experience in the jewelry industry. I was a leading expert in historical appraisals at Macduff's, a prestigious auction house, where I served as their senior vice president. I've also worked with several museums, auction houses, and private collectors through my own independent firm.
Ms. Marquez, what is a jewelry appraisal?
It's how we determine the value of a piece of jewelry.
How do you go about doing that?
I examine the piece, test its composition, and review any of its supporting documents in an effort to determine the item's provenance, all of which is within industry standards.
Ms. Marquez, what is provenance?
It's a way to determine if an item is what it is purported to be by attempting to trace its ownership from the present back to its claimed origin.
Did you perform a jewelry appraisal for today's case?
I did. I was retained by the defense to examine Mr. Scher's ring and its supporting papers, specifically to determine whether or not it belonged to William Shakespeare.
Your Honor, pursuant to Stipulation 4, the parties have agreed that Ms. Marquez is a qualified expert in antique jewelry appraisals.
So noted for the record.
Ms. Marquez, if you could please turn to Exhibit B in the binder in front of you. Do you recognize this exhibit?
I do. It's a photo of the ring I examined.
What did you find upon your examination of this piece?
I found that this ring is 14 grams of gold and could have dated back to the Elizabethan era.
Earlier you mentioned provenance. Were you able to establish provenance for this piece?
No, I was not.
Why is that?
I found no concrete evidence directly linking this ring back to William Shakespeare.
What do you mean by concrete evidence specifically?
Well, there is paperwork suggesting that this ring may have belonged to Shakespeare. Both sources of that paperwork recognize that it is of doubtful authenticity.
Are you familiar with R.E. Couch's report?
I am.
Do you agree with his conclusion?
I read Miss Couch's report, but I don't agree with her analysis of the ring's history.
Why is that?
Well, the chain of custody she references includes over a century-long gap where the whereabouts of an original ring are unknown.
Based on your examination of the ring and your analysis of the evidence, were you able to determine this ring's provenance and value?
This ring cannot conclusively be linked to William Shakespeare, and as such is worth around $770.
Thank you, Ms. Marquez. Your Honor, at this time I have nothing further.
Cross-examination.
Yes, Your Honor. May I proceed?
You may.
The defendant hired you to testify in this case, is that correct?
I was retained by the defense.
In your statement, you note that the signet ring may date back to the 15th or 16th century.
Yes, it is of Elizabethan style.
Now, this would be around the Shakespearean era, right?
I believe Shakespeare lived during then.
In your statement, you also note that the W and S markings are consistent with the Shakespearean era, right?
Again, it is of Elizabethan style.
Yet, you also go on to state that the ring could have been created long after Shakespeare died, right?
Yes, it could be a counterfeit or a forgery.
But you also go on to state that the ring could have been owned by, say, a W.S. or William Smith during Shakespeare's life.
Yes, my point was that there are many possibilities of where this ring could have came from.
So let me see if I can get this straight. This ring bears markings W.S. similar in style to the Shakespearean era, right?
The Elizabethan era, yes.
And this ring's overall appearance is also consistent with that of Shakespeare's?
Of the Elizabethan era, yes.
Yet, in your words, there is no evidence for this court to conclude that the ring once belonged to William Shakespeare.
No conclusive evidence.
Thank you. No further questions, Your Honor.
Any redirect examination?
Yes, Your Honor.
Miss Marquez, is a similar style to Elizabethan pieces indicative of the fact that this ring belonged to William Shakespeare?
Not at all. As I said, this ring could have belonged to someone else during that time period, or it could have been a counterfeit created much later.
Thank you, Miss Marquez. Your Honor, I have no further questions. May this witness please be excused?
Yes, you may. Thank you for your testimony. You are excused.
Your Honor, prior to calling our next witness, the defense would like to request a time check on behalf of both parties.
The request is granted.
The prosecution has 8 minutes and 39 seconds on cross, and the defense has 9 minutes and 53 seconds on direct.
Thank you, Mr. Clerk.
All right, please call your next witness, counsel.
Yes, Your Honor, the defense calls Ezra Weintraub to the witness stand.
Ezra Weintraub, please proceed to the witness stand. Please stop and face me and raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? I do. You may be seated. Please state your full name, spelling your last for the record.
Ezra Weintraub, Weintraub.
May I proceed, Your Honor?
You may.
Good afternoon, Miss Weintraub.
Good afternoon.
What do you do for a living?
I'm head of security on board the Heart of the Ocean cruise ship.
What does your job entail as head of security?
It's pretty standard. I monitor our security cameras, guest Wi-Fi, and keycard usage.
Now, Ms. Weintraub, are cell phones permitted on board the Heart of the Ocean?
Yes, ma'am. Cell phones are permitted.
Now, were you working on the night of June 9th, 2022?
I was. I was working the later shift, 7 p.m. to 7 a.m.
Did you have any contact with the Portsmouth police that night?
I was contacted by a Detective Dylan Mavis.
Did Detective Mavis request video footage from you that night?
She did. She requested footage from between the hours of 11 p.m. June 9th to 3 a.m. on June 10th.
Were you able to provide her with that footage, Miss Weintraub?
No.
Why not?
Simply, ma'am, because she asked too late.
What do you mean by too late?
Well, although our cameras run 24/7, all day, every day, if footage isn't requested by 3 a.m., it's deleted.
Now, Ms. Weintraub, you mentioned that you monitor security cameras. Do you monitor a camera outside of the cast dressing room on board?
I do. There's a camera positioned in the hallway outside.
Did you see anyone enter on the night of June 9th?
Well, yes, it was the end of the production. I saw several cast members come and go.
Do you know a Billy Scher, Ms. Weintraub?
Actually, I do. I was able to catch a performance of Macbeth at Sea right before it closed.
Can you tell the court whether you saw Billy Scher enter that night?
Ma'am, I monitor 18 different security cameras simultaneously. I truly couldn't give you a yes or no to that question.
Now, Ms. Weintraub, I'd like to talk with you about the layout of the Heart of the Ocean. Are you familiar with it?
Yes, I'd say so.
Well, based on your experience working on board, can someone go from Billy Scher's cabin to the Midnight Lounge without passing through Deck 7?
No, ma'am. That's physically impossible.
Can someone go from Billy Scher's cabin to the Midnight Lounge without passing by the Blue Diamond Cafe?
No.
Thank you, Ms. Weintraub. Your Honor, I have nothing further at this time.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Now, Ms. Weintraub, you said that you recalled watching a performance just a few nights before June 9th.
I was able to catch a performance in early June.
Now, you said you know the cast members quite well in your witness statement, isn't that right?
I'd say so. I've been working on board for 8 years now.
And you said that there was a camera positioned outside the cast dressing room?
Exactly.
Yeah, in your witness statement, you said that you weren't able to recall Billy Scher entering the dressing room, isn't that right?
Exactly. I couldn't be sure if I saw him or not.
Now, you were able to recognize other cast members entering the dressing room that night, isn't that true?
I recall seeing Carter Lucky and Jordan Franks, but nobody else in specifics.
And you saw them entering the dressing room separately after the performance had ended, isn't that right?
Yes.
So, to be clear, after the performance ended, you saw Jordan Franks entering the dressing room alone?
As I said, I saw Jordan enter along with several other cast members.
But they entered alone, isn't that right?
Yes.
Thank you. No further questions.
Any redirect examination?
No redirect, Your Honor. May this witness please be excused?
Yes. Thank you for your testimony. You are excused. Next witness for the defense.
Prior to proceeding, the defense requests a time check on behalf of both parties.
That request is granted.
The defense has 7 minutes and 21 seconds on direct, and the prosecution has 7 minutes and 36 seconds on cross.
Thank you. At this time, the defense calls Carter Lucky to the witness stand.
Carter Lucky, please proceed to the witness stand. Please stop, face me, and raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
You may be seated. Please state your full name, spelling your last for the record.
Carter Lucky, Lucky's Lucky.
Good afternoon, Mr. Lucky.
Good afternoon.
What do you do for a living?
I'm an actor, or at least I'm trying to be. I recently got my first role in Macbeth at Sea.
How long were you with Macbeth at Sea?
I'd say about 6 months.
Do you know someone named Jordan Franks?
Yeah, absolutely.
How do you know Miss Franks?
Well, we started off as crewmates, but now we're close friends. We talk all the time.
Would you say you know her well?
Certainly. I'd even consider her my mentor. She really took me under her wing when I first got here.
Are you aware of the fact that Miss Franks has been charged with robbery?
I am, yes.
Is that consistent with the Jordan you know?
No, absolutely not.
Are you aware of the fact that Miss Franks has been charged with battery?
Yes, I am.
Is that the Jordan you know?
No, that's not Jordan.
Do you know a Billy Scher, Mr. Lucky?
Yes, I do.
How do you know Mr. Scher?
Well, he was another member of the cast on Macbeth at Sea.
Based on that experience, do you have an opinion as to whether Mr. Scher is trustworthy?
I do.
Objection, Your Honor. Speculation.
Your response, counsel?
Your Honor, this is permissible character evidence under Rule 8.
Any final comment?
No, Your Honor. Withdrawn.
The objection is overruled. You may answer.
Could you please re-ask the question?
Of course, Mr. Lucky. Based on your experience with Mr. Scher, do you have an opinion as to whether he's trustworthy?
He's not. He's manipulative.
Now, did you see Miss Franks and Mr. Scher interact on the night of June 9th?
I did. I was coming back from the rap party when I heard some shouting, which I thought was coming from their room.
What did you do when you heard this shouting?
Well, the door was open, so I went to take a look.
Mr. Lucky, it's the prosecution's contention that Miss Franks pushed Mr. Scher to the ground. Is that what you saw?
No, if anything, Billy's the one who ran into Jordan.
Thank you, Mr. Lucky. Your Honor, I have nothing further at this time.
Cross-examination.
May I proceed, Your Honor?
You may.
You consider Jordan Franks as a mentor, isn't that right?
Absolutely.
Now, you attended the cast party, isn't that true?
Yes, it was great.
And you were conversing with Jordan Franks?
Along with other cast members.
Now, didn't Jordan Franks say something along the lines of that they hoped Billy Scher would break a leg?
She said something like that, yeah.
Now, moving on, Jordan Franks left a while before you did, isn't that right?
That's right, yes.
And you left around midnight?
That's right.
And after leaving, you headed towards Billy Scher and Jordan Franks' cabin room, isn't that true?
I realized I hadn't seen Jordan, so I went to go find her.
And down the hall, you testified to hearing shouting?
Yes.
And the cabin was dark, isn't that right?
That's right.
So, to be clear, you couldn't see exactly what was happening in the cabin room?
The light in the hallway helped me get a good idea.
Now, you heard an altercation ensue, isn't that right?
Yes, that's right.
And you heard Billy Scher fall to the floor, isn't that right?
Oh, I saw it, yes.
And in fact, Billy Scher cried out in pain, isn't that right?
Yes?
And you just stood in the doorway, isn't that true?
Objection relevance?
What's the relevance?
Your Honor, Carter Lucky has witnessed the fact that an altercation has ensued, and the fact that they just stood in the hallway goes to show the fact that they witnessed the event that occurred without interacting with the two of them.
May I be heard, Your Honor?
Any final comment?
The fact that Mr. Lucky didn't stop to help Miss Frank or Mr. Scher when he saw him fall has no relevance in today's case.
The objection is sustained.
Moving on, after the altercation had ensued, you conversed with Jordan Franks, isn't that right?
Yeah, I told her I'd meet her at the Blue Diamond Cafe.
And you said that you would meet her 30 minutes later, isn't that right?
Something like that, yes.
And isn't it true that you can walk from the cast and crew member floor to the Blue Diamond Cafe in just 15 minutes?
That's right, yes.
Yet you met 30 minutes later.
Objection relevance?
Your Honor, this goes to show the time frame of what had occurred right after the altercation had ensued.
Final comment?
Your Honor, the fact that it took Mr. Lucky 30 minutes to meet Miss Franks as opposed to 15 has no relevance on the facts of today's case.
I respectfully disagree, so with respect to that objection, that's overruled.
Okay. Moving on, you met 30 minutes later, isn't that right?
Yes, we did.
And you conversed in the Blue Diamond Cafe.
That's right.
Thank you. No further questions.
Any redirect examination?
Yes, Your Honor. Mr. Lucky, you were asked on cross-examination about the phrase, break a leg. What does that mean in theater speak?
It's just our way of saying good luck to each other.
Thank you, Mr. Lucky. Your Honor, I'm nothing further at this time. May this witness please be excused?
Yes. Thank you for your testimony. You are excused. Any additional witnesses?
Yes, Your Honor. The defense calls Jordan Franks.
Jordan Franks. Please proceed to the witness stand. Please stop and face me and raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
You may be seated. Please state your full name, spelling your last for the record.
My name is Jordan Franks, Franks.
Your Honor, may I proceed?
You may.
Good afternoon, Miss Franks.
Good afternoon, ma'am.
What do you do for a living?
I'm a professional actress. Most recently, I starred in Macbeth at Sea on board the Heart of the Ocean cruise ship.
How long were you on board the Heart of the Ocean?
I was there for about 4 years. We closed on June 9th of 2022.
Do you know someone named Billy Scher?
I do. Billy was a castmate of mine, and he was also my roommate.
How would you describe your relationship with Mr. Scher?
I respect Billy as an actor, but we didn't really get along too well.
Miss Franks, I'd like to talk about June 9th, 2022. Did you attend a cast wrap party that night?
I did. I was there for a few hours, but I left around 11.
Did you go anywhere else that night?
About an hour later, I decided to go get a snack from the Blue Diamond Cafe.
Did you hear Mr. Scher testify today about an encounter that happened between the two of you in your cabin at around midnight?
Yes, I was, but that's not what happened.
Could you please tell the court your recollection of the events?
Yes. It was around midnight that I decided to go to the Blue Diamond Cafe. I was grabbing my phone off the dresser when Billy burst into the room. It seemed like he was taunting me.
About what?
About the fact that he had the lead in Jefferson the Musical, and I didn't.
Did you respond?
I did. Pardon me. No, I just wanted to get out of there.
Did you, we heard Mr. Scher testified today that you said you don't deserve the role or the ring. Miss Franks, did you say that?
No, he's lying.
Did you intend to bump into Billy Scher?
No, of course not.
Miss Franks, did you go anywhere after this encounter?
Yes, after we collided, I continued with my plan to go to the Blue Diamond Cafe.
Did you see Detective Dylan Mavis when you were there?
I did. She came up to me and asked if I recognized a box that she had found in the trash can.
Did you recognize it?
I did. It was Billy's signet ring box, and that's exactly what I told the detective.
Miss Franks, did you put that ring box in the trash?
No, I don't even remember seeing the ring box or the ring that night before the detective showed it to me.
What happened after you and the detective spoke?
She escorted me back to my room, and she asked if she could search it.
Did you let her?
I did.
What happened after the detective searched your room?
She asked me to stay put. She said she had to complete her investigation on the rest of the ship.
Did you stay put?
Yes, I hadn't done anything wrong.
Miss Franks, I want to be clear. Did you steal Billy Scher's ring?
2 minutes.
No, I'm being framed.
Thank you, Miss Franks. Your Honor, I have nothing further at this time.
Cross-examination.
Yes, Your Honor, the prosecution calls for a time check.
The prosecution has 5 minutes and 54 seconds left on the cross.
Your Honor, I'd like to request a time check for closing arguments on behalf of both parties.
For closing arguments, the prosecution has exactly 6 minutes and the defense has 5 minutes and 19 seconds.
You're an actor, correct?
Yes, I'm a professional actress.
You're also a big fan of William Shakespeare?
Yes, I am, an avid fan.
A self-proclaimed huge William Shakespeare fan?
Yes, sir.
You've starred in numerous Shakespearean plays, right?
Yes, some off-Broadway, some on Heart of the Ocean as well.
So you starred in Macbeth on Heart of the Ocean, right?
Yes, that's correct.
Now, Billy Scher was your roommate aboard this ship.
Yes, for 3 years.
And you shared a cabin together?
We did.
And it was a quite small cabin.
Yes, it was pretty small.
And like you said, for 3 years.
Yes, sir.
So you shared the same 150 square foot room and performed together 4 nights a week for 3 years.
Yes, that's correct, sir.
Now, Cher's grandmother worked aboard this ship, right?
I think she helped write the play, but her grandmother didn't work on the ship.
She worked as a casting director?
Yes, she did, but she wasn't on the ship, sir.
You thought Cher got special treatment?
I felt like she did sometimes, or he did sometimes, just because of his family connections.
Moving on to your love of Shakespeare, you're a bard later, right?
Yes, I am a fan of Shakespeare, sir.
You once said that so few things belonging to William Shakespeare are still around.
Yes, it's true. There are rarely found artifacts of William Shakespeare that are really his.
And then in April 2022, Cher was gifted a ring, right?
Yes, from Cleo Schaefer.
A ring with the initials W.S. on it.
Yes, that's correct.
A ring in which he claimed once belonged to the William Shakespeare.
Yes, but I wasn't really sure if that was true.
Cher wore this ring a lot, right?
During every performance of Macbeth at Sea.
And he would keep this ring in a black velvet ring box, correct?
Yes, that's correct.
A ring box which he would keep in your cabin at night.
Yes.
You once said that something with W.S. initials on it could cause quite a stir at an auction.
If it was real, it could really cause a stir. Yes, sir.
Moving on. Oh, excuse me. To be clear, those were your words, though?
Yes, sir.
Moving on to June 9th. That morning, you were cast in Jefferson the Musical, right?
Yes, I was cast as the understudy. It's a very good opportunity to be on Broadway at all.
And this would commence performances June 20th in New York City, right?
Yes, that's correct.
And this was a dream role for you.
Yes, being on Broadway is an amazing opportunity for any actor or actress out there.
And like you said, you were cast in the lead role, but as an understudy, right?
Yes, sir.
Cher got the lead role.
Yes, that's correct.
Cher always gets what Cher wants.
Yeah, it sure did feel like that sometimes.
Cher stole my dream role. You said that?
I did say that, but I've realized that having any role on Broadway is a great opportunity.
Moving on to later that night, you got upset with Cher during the final showing of Macbeth, right?
Yes, I did.
He mixed up some lines, and I felt really embarrassed in front of the whole audience.
Embarrassed enough to make you angry, right?
Yes, that's exactly why I confronted him about it after the show.
Later that night, you went to the cast party, right?
I did, yes.
And you left around 11?
Yes.
You went back to your cabin?
I did. I went back to my cabin for about an hour, and then I decided to go to the Blue Diamond Cafe.
And you were in the cabin for an hour by yourself?
Yes, that's correct.
And then, like you said, you decided you needed to go to the Blue Diamond Cafe?
Yes, I wanted a snack.
You went up to turn off the light?
Yes, the light was off when I was planning on leaving.
And at this moment, Cher enters the room, right?
Yes, Billy burst in and started taunting me.
So, Cher was yelling at you, right?
Yes.
Said?
Yes.
And you were yelling back.
No.
Now, Cher was blocking the door, correct?
Well, he entered where the door was, yes.
And you still needed to get out of the room.
I wanted to get out of that situation, yes.
So, you touched Cher on your way out of the room, right?
We sort of collided as I was trying to leave, and he fell.
To be clear, there was physical contact on your way out of the room.
Yes, but I didn't mean to hit Billy at all. I just wanted to leave.
Cher was the one who fell to the ground, right? You were left standing?
Yes, that's correct.
And then Cher, when he fell, he started crying out, right?
I think he yelled or screamed, yes.
So we can agree he was crying out in pain, right?
Your Honor, objection, speculation.
Your response, counsel?
Your Honor, the Jordan Franks clearly saw, as she testified, Franks fall and hit his arm, and she admits she was yelling in some form of emotion, and it's a reasonable interpretation to believe that she could have noted that was pain.
Final comment?
Yes, Your Honor, an interpretation clearly means that this is speculation. Opposing counsel is asking my witness to speculate as to why Billy Cher was screaming.
The objection is overruled.
Crying out in pain, right?
Well, at the time, I didn't know Billy had been hurt or broke his arm, so I wasn't sure. I just thought he was being dramatic.
And you left
1 minute.
anyway.
Yes, because I didn't know he broke his arm.
Showing you it has been marked as, or flip to Exhibit A, please. That was found in your safe, correct?
Yes.
And you took the time and effort to research what Billy Cher's ring could be worth.
Well, I am a fan of Shakespeare, as we already established.
Objection, non-responsive. I asked the witness, I asked the witness whether she took the time to research what the ring was worth.
The objection is sustained. Please answer the question.
Can I move to strike from the record?
That's granted.
Would you like me to repeat the question?
Yes, please.
You took the time and effort to research what Billy Cher's ring could be worth.
Yes, I was curious if it was real or not. I'm a fan of Shakespeare.
You got an appraisal on your own roommate's property.
No, I just wrote down the number.
You also wrote the words Shakespeare's heirloom.
Yes, I did, but as you can see...
Objection, non-responsive.
That request is respectfully denied. Why don't we allow the witness to answer the question? Go ahead.
Well, I was just saying I wrote question marks all over this paper. I wasn't sure if any of it was true or not.
Later, Detective Mavis found you in the ship's cafe, is that right?
Yes, I was sitting there when the detective approached me.
She showed you a black velvet ring box?
Yes, she said she found it in the trash can, and she asked if I recognized it.
And this ring box was found in extremely close proximity to where you were sitting. Thank you, Your Honor.
Any redirect examination?
Yes, Your Honor. Ms. Franks, could you please direct your attention to Exhibit A? Why did you write this note?
Well, I'm a really big fan of Shakespeare, and I wanted to know if this ring that Billy was showing off in front of us was fake or not.
Were you sure that this ring was authentically Shakespeare's?
Of course not. I had no idea if it was real or fake.
We also heard that when Mr. Cher fell, you didn't stop to help. Ms. Franks, why is that?
Well, I didn't know that he was hurt, especially not that he'd broken an arm.
Thank you, Ms. Franks. Your Honor, I have nothing further. May this witness please be excused?
Yes, you may step down from the witness stand and return over to counsel table. Any additional witnesses from the defense?
No, Your Honor. At this time, the defense rests.
All right, at this time, prosecution, would you like to give your closing arguments?
Yes, Your Honor. May I proceed?
You may.
No one on that ship had the unique combination of motive, knowledge, and opportunity, like Jordan Franks had on June 9th after leaving that cast party and heading back to her cabin. The ensuing string of culpable actions as she swiftly attempts to conceal her crime are more than just evidence of Jordan Franks' guilt. And while they weave a case bound to the theory that Billy Scher did it, the defense has promptly chosen to write off Jordan Franks' bumblingly obvious missteps as pure coincidence. Your Honor, first to establish why Jordan Franks is guilty, far beyond any other reasonable conclusion, let's examine the motive. No one is disputing that Franks had a long-standing jealousy and hatred of Scher. He was a more successful actor. He stole Frank's dream role, and he owned a signet ring that Jordan Franks was absolutely obsessed with. So infatuated with that she spent loads of time researching it, hiding the guilt in her safe. The defense would like you to believe this to be a coincidence, like everything else in their case. Your Honor, let's not even pretend that Jordan Franks didn't have the motive to steal that ring, because it wasn't the motive that finally made her take it. It was the opportunity. We know that Billy Scher always kept that ring in his ring box, locked away in his safe every night. Perhaps this is why Jordan Franks took such an interest in finding out if that ring was truly once indeed owned by William Shakespeare. She wanted to see if that ring was truly as valuable as Scher claimed it to be. And then she got her answer. Shakespeare's heirloom. So just imagine, Jordan Franks' surprise, after a long and contentious day with Scher, when she walks back into her cabin only to find that very ring box sitting on the nightstand, free for the taking. At this moment, the opportunity was laid at her feet. After all, this was the very ring owned by the man she hated. The very ring she had spent loads of time researching. The very ring she believed to have once been owned by the William Shakespeare. So of course, in this instance, Jordan Franks decides to commit her first crime, grand theft. She moves to take the ring. But at this very moment, the stakes drastically elevated as Billy Scher enters the room. This was no longer just a simple theft. Scher was now present in the room. This had become a robbery, and Jordan Franks was caught red-handed. She now had a choice to make. She can put the ring box back down on the table and play it off, or she can take the ring. The innocent caricature the defense wants you to believe Jordan Franks to be certainly would have left the ring box on the table. But no, in this moment, Franks doubles down, yelling, "How could you do this to me? You don't deserve the role or the ring. Get out of my way." Franks rushes Scher, intentionally shoving him to the side, breaking Scher's arm, watching as he falls and hits the nightstand. She then rushes out into the hallway, ring box in hand. Jordan Franks' wish that Scher would break a bone so she could acquire her dream role in Jefferson the Musical had come true. And I asked the defense, is this a coincidence as well? Because Franks didn't even look back. After hearing her own roommate cry out in pain, she was all in. She had elevated her crime to battery. But soon after, Franks became desperate. She is now in possession of the ring box and she needs to hide it, but she isn't willing to get rid of it entirely. No, then she would have just thrown it off into the ocean. No. Franks wants to take the ring and take it to New York City, where she will become the star in Jefferson the Musical. Everything was going perfect. She rushes over to the cast dressing room, where she hides the ring, unknowingly being spotted by Weintraub. She then rushes over to the Blue Diamond Cafe, to hide the ring box, where she's spotted by Cleo Schaefer. Maybe what Jordan Franks thought was the perfect crime had completely fallen apart. Her opportunity, while ideal in the moment, had deceived her. It was a house of cards. Detective Mavis arrests her not long after for the obvious crime that has been committed. Franks then suddenly decides to change her opinion regarding the value of the ring, hiring Miss Marquez to testify against its authenticity. But Miss Marquez has failed Franks entirely because all of her theories contradict each other. She says the ring was probably a counterfeit that was created long after Shakespeare died. But if not, it was probably owned by a William Smith during Shakespeare's life. But if not, you see where I'm going with this, you get the picture. She's talking out of both sides of her mouth. In fact, all of the witnesses in Franks' favor are equally incoherent. Carter Lucky isn't just biased. She is completely manipulated. Franks is her mentor. Franks told her endlessly about the ring and the crazy amount of money it was worth. And now, Miss Lucky wants to call the ring fake. Maybe he'll trick us next time. And then there is Weintraub, the security guard who has worked aboard the Heart of the Ocean for 8 years. The security guard who personally knew Jordan Franks, watching him perform a few nights earlier. The security guard who saw Jordan Franks confidently stroll right on into the dressing room where the ring would later be found. But of course, Weintraub just couldn't know what he was seeing according to the defense. This is another instance of obvious guilt the defense is attempting to mask as a coincidence, but we don't buy it, Your Honor. Jordan Franks' guilt has become apparent. They really think Billy Scher did it. That is their theory. The person who got the role over Jordan Franks. He would steal his own ring to frame her? It just doesn't make any sense. They're perpetuating more coincidences in their theory. They're throwing spaghetti out the wall and seeing if it will stick. But if we take a closer look, we realize nothing of what they have said is of any substance. Billy Scher could not have committed that crime. No one but Jordan Franks had the same motive, opportunity, and knowledge. Because of this, I ask that this court find Jordan Franks guilty of grand theft, robbery, and battery. Thank you.
Thank you, counsel. Defense, would you like to give your closing argument?
Yes, Your Honor. I'll be referring to Exhibit D during my argument. Do you have a copy of the exhibit available to you?
I do.
Thank you. May it please the court. I was framed. That's what Ms. Franks told you today, Your Honor. That's not just what she told the court. That's what she told Detective Mavis at the start of her investigation. Billy Scher had left a breadcrumb trail of a staged crime for Detective Mavis to follow. And the detective took the bait, never once considering that Ms. Franks might have been telling the truth. Your Honor, the prosecution just told you that only Ms. Franks had the specific motive, knowledge, and opportunity to commit this crime. But we know that's not true, because we learned today that Billy Scher had the means, the motive, and the opportunity to stage this crime and frame Ms. Franks. So let's walk through what happened. On the night of June 9th, an altercation ensues backstage after the final performance of Macbeth at Sea, after which Mr. Scher returns to his cabin. While there, he tells you that he takes off his ring. But Your Honor, we know that's not true. Ms. Franks told you today she didn't see the ring box when she returned to the cabin later that evening. So we know that Billy Scher had to take it with him. So let's go through his route. As your Weintraub told you today, it's impossible for someone to walk from deck 2, where the cabin is, to deck 8 without walking through deck 7. So Billy Scher walks through deck 7, and in doing so, goes through the cast dressing room, where he puts the ring in there. Then he walks through the Blue Diamond Cafe on his way to the Midnight Lounge, throws away the ring box in the trash. Your Honor, Billy Scher's route includes everywhere that evidence was recovered. And, Your Honor, later that night, Billy Scher returned to his cabin, expecting to simply falsely accuse Miss Franks of stealing his ring. But when Miss Franks tried to leave, Billy Scher moved and blocked the exit, and the two collided. There was no battery. But why did he take 15 minutes to call 911? Your Honor, he had to come up with a story to tell the police. And as for motive, Your Honor, you heard over and over today of the rocky relationship between Miss Franks and Mr. Scher. Now, the prosecution would like you to believe that this relationship only exists in Miss Franks' mind. But Your Honor, a relationship is a two-way street. So we know that when Mr. Scher got the call on the morning of June 9th telling him that Miss Franks would be following him to New York City, he reached his limit. He had to do something. So while the play had ended, the acting certainly hadn't. Your Honor, to be clear, we didn't have to prove anything today, but we have provided the court with a reasonable alternative to the unreasonable theory that the prosecution has told you today. As the court knows, pursuant to Calcrum 224, when presented with two reasonable interpretations of circumstantial evidence, the court must adopt the interpretation that points towards innocence. Today, the prosecution told you to convict my client of robbery. But Your Honor, they can't even connect Billy Scher's ring to Miss Frank's. Remember that the testimony of Detective Mavis as to whose costume the ring was found in, that was stricken. You cannot consider that evidence in your ruling today. And as such, they have failed to meet their burden. They also want you to believe that Miss Franks took a ring box and threw it away in a trash can and then sat down next to it until the police arrived. That's not reasonable. And who told Detective Mavis that the ring box belonged to Billy Scher? Jordan Franks. Why do that if you're trying to conceal a robbery? Billy Scher framed Jordan Franks. The play had ended, but the acting had.
Stop.
Rebuttal argument from the prosecution.
Yes, Your Honor. The defense keeps emphasizing that this crime must have been committed by Billy Scher. And one thing they did get right in their closing statement is that there does need to be a reasonable and plausible theory alternative in order, and if there is one, that their client can be acquitted. But the theory that Billy Scher committed this crime is simply absolutely outrageous. They keep addressing the possibility. Yes, he could have taken those 15 minutes, but what was the motive? He had gotten the role over Miss Franks.
30 seconds.
And suddenly he just decides that he's so worried that he needs to frame her. He steals his own ring. I don't understand the motive. They're not producing a reasonable or plausible or even structurally coherent theory to prove that it was Billy Scher. It is simply just outrageous. Thank you.
Thank you, counsel. Rebuttal argument from the defense.
Yes, Your Honor. Who had the means, the motive, and the opportunity? Who had unfettered access to Billy Scher's ring? Billy Scher. And who did you hear from over and over again disliked Miss Franks? Billy Scher. Your Honor, when Mr. Scher found out that Miss Franks would be following him to New York City as his understudy, where they would work together for the foreseeable future, he snapped.
30 seconds.
He couldn't take it anymore. He knew what he had to do. Stage the crime, frame Miss Franks. Your Honor, the play had ended, but the acting surely hadn't. Please find Miss Franks not guilty on all counts. Thank you.
Thank you, counsel. So before I rule, students may confer with their attorney, teacher, coach regarding any trial irregularities. So please do so now. Would the prosecution team like to note any trial irregularities?
No, Your Honor.
Would the defense team like to note any trial irregularities?
None from the defense, Your Honor.
All right, at this time, the court has deliberated. And at this point in time, Ms. Franks, the court has considered the evidence presented. I am persuaded by the defense argument in this case, and I do find that Ms. Franks is not guilty of all charges. So that is the court's ruling in this matter. Now, with respect to this matter at this time, I understand that there's going to be a selection of MVPs for opposing teams. Is that correct?
Yes, Your Honor.
All right, so at this point in time, teams, you have 2 minutes to decide which student from the opposing team should receive the MVP certificate. And to our attorney scores, let me know when you all are ready to proceed, okay? You ready?
Yes.
All right, so while the attorney scores are still working on calculating their totals, and you folks feel free to let me know when you're ready to proceed, okay? I'm going to start off and just make some comments here. And I want to say that I got to tell you, I'm just going to speak from my heart. I don't have any script or anything like that, but I'm going to tell you that this was a very remarkable performance on both sides. You know, I've had an opportunity recently to head over to USF School of Law and work with some law students that were participating in a oral advocacy competition. And I had a chance to see some folks that are already law students that really struggled to answer questions that were posed by the judges that were participating in the competition. And these folks are in law school. You folks are in high school. And I thought that you did an outstanding job in the way that you carried yourself, the way that you handled your responsibilities. It was absolutely impressive. You know, over the past couple days, I had the benefit of being able to spend some time at the Judicial Council in San Francisco, where I was attending a leadership supervising training or conference. I had the pleasure of meeting our Chief Justice of the Supreme Court, who really inspired us with some comments, very inspiring and motivational comments. I had the benefit of being among different seasoned and experienced judges, many of whom have had long, outstanding careers, have done a great deal of work, and had the opportunity to really be inspired by their guidance, their counsel, their mentoring. And then I had a chance this morning. I was in San Francisco at the USF School of Law, meeting with law students. I was asked to meet with about 35 to 40 law students. So we were meeting at the law library about 8 a.m., and it was truly a pleasure to listen to these students who are motivated, that are hungry to get out there and to be lawyers, contributing to our system of justice, advocating for the community. And then I have the benefit of coming in this afternoon and presiding before you and being treated to an absolutely excellent presentation. Every day that I wake up, I always try to remind myself of a reason to give a sense of gratitude for getting another opportunity to wake up and be alive and to live. And no doubt that over the past few days, they've been outstanding days, and I've been treated to a lot of things that have made me feel very grateful. And when I get an opportunity to see our youth getting out there and doing some things that are just remarkable, showing a desire to get better, hungry to get out there and learn, also taking the opportunity to learn how to interact with people who have life experience, who are seasoned, your teachers, your attorneys, anybody else that was involved in this process. The fact that you have now taken steps to learn and acquire lessons that are being shared, and then you are applying those lessons, that shows tremendous aptitude. And that is remarkable to see in our youth here today. And that just shows that the future is very bright when we have people like each and every one of you who are getting ready to get after it, to pursue your next level of academic challenges, to get your degrees, and then ultimately get into the professional career paths that you choose to pursue. And if you keep on doing what you're doing, you know, all the hard work that you're putting in right now to get better each and every day, to work on your weaknesses and then to continue reinforcing those strengths, all of you are going to be tremendous forces in our community, doing a lot of good work, to help a lot of people propel forward. And I thank you for taking the time to do that and for giving me an opportunity to bear witness to what you've obviously demonstrated here, a true testament to the strength and your desire to get better and to be the best that you can at what you do, especially when it comes to the law, because that's, you know, the profession that I really deeply respect the profession that I love, that I'm passionate about, and I just want to see nothing but good people coming in and allowing our system of justice to keep running strong and to command the respect of the community. I want to say that I don't want to get into a lot of the technical and specific things that you did that I know you're being scored on. I'm going to allow counsel who have taken the time to be here to talk about those specifics, but in general, I will comment on some observations that really impressed me. I mean, first of all, I want to make sure that I always take care of my courtroom work group, the people that have my back in this courtroom. And I got to say that I might have a conversation with folks in my court to see if there's any way I can get this bailiff to be working for me, because I love that no-nonsense, serious attitude. I mean, I don't think that anybody was ever going to think about doing anything that was out of line or along the lines of any improper court decorum. I thought that you were impressive. I really appreciate the way that you handle yourself and carry yourself. You were an outstanding bailiff. So thank you very much for having our back in here. For our timekeeper, my goodness, I don't know how you folks feel, but I don't know how I would be able to keep track of all the time and then just on an instant have some request that's dropped about, hey, time check, and then you got to be precise. But I don't think that this gentleman here to my right ever hesitated. I mean, he was ready to call. He was ready to go whenever called upon, and he was accurate. I didn't hear any objection from anyone here, so obviously he was 100% accurate each time. So I think that there's a lot of kudos that we got to show to this gentleman right here for handling his responsibilities in a very responsible and excellent way. So thank you very much for doing that. And for our clerk over here, thank you very much for helping us out. Thank you very much for being here as a backup also to this gentleman and making sure that we were running smooth. I don't think we had any concerns in here, and that's because you folks handled your responsibilities well. So I just want to make sure that you're properly recognized. Do we have any courtroom artists? All right, so, I know that in prior occasions, people don't really say anything about the courtroom artist. I don't know if we have any ability to be able to display your work, but I want to make sure that we get an opportunity to have the folks here in this courtroom see the work product that you generated. Were you able to generate anything today? Then why don't you show folks here the final work product? Very nice. Outstanding job. Thank you very much for your work. You did a great job. And our attorneys, oh my goodness, let's start with the arguments on the search and seizure motion. The young lady from Carmel High School, my goodness, I thought that you were just outstanding. You had a tremendous command of all the different cases. You had a command of the facts. You weren't repeatedly looking at your notes. I mean, you knew exactly what this case was about. You were able to cite to all the different cases that we talked about. You were able to give me some recitation of the facts, talk about the holdings. I mean, it's evident that you put in a lot of time to prepare, but your delivery was fantastic, and I thought you did an outstanding job. Same thing with our formidable oral advocate from RLS. This is not an easy assignment to have to deal with. And like I mentioned, it wasn't too long ago that I saw attorney or law school students who were engaged in oral advocacy doing the same thing that you were doing, and they were faltering and they couldn't continue. Broke down, couldn't continue. But you kept going, you kept arguing, you kept presenting your arguments and relying on the authority that you had studied and obviously, utilized in support of your arguments. And I thought that you did a fantastic job as well, because it is not an easy thing to do, especially when you get peppered with questions and you get frequently interrupted. Then you have somebody over here that's shouting times at you, and, that's easy to get your attention really distracted. But, both of you really stayed on task, and, that was quite impressive. So I appreciated the quality and caliber of your work, and I thought that you did an outstanding job. Thank you very much for that fantastic presentation by both of you. Our attorneys, I love the fact that you each had your own style. Some of you had your own little swagger. I mean, I love seeing that because that's just you. You're just being yourself. It's not easy to get in front of a room full of people and then to take on a witness not knowing what to expect. Sometimes a witness will not give you the response that you're anticipating or expecting. Sometimes they may refuse to answer, they may dance around. And I thought that attorneys on the Carmel side, attorneys on RLS side did a really good job of trying to corral the witnesses and make sure that they bring it to the witness's attention that that's not the question that I asked, so answer the question. I love that. I love the fact that you were really working hard to maintain control and command of your examination and not letting the witness take control of the examination. So I really appreciated that. And is it Emma?
Yes, Your Honor.
Outstanding job. Outstanding job on your directs and your cross-examination and also on your closing argument. You did exceptional. The way you present yourself, the way you carry yourself, your delivery. I can easily see you right now appearing before a very distinguished judge like Judge Panetta, whose courtroom we're in, just handling business in a real case. I mean, you look like a lawyer in here, and a formidable lawyer, so you did a fantastic job. I mean, each and every one of you. Same thing with Ms. Cho. I mean, you come in and you're polished. You did a heck of a job, outstanding job, and like I said before, it's just absolutely impressive to see you both handling your responsibilities in the way you did because you guys were just solid. And on RLS's side, Mr. Eubanks, and you were just delivering with a lot of thunder. You were super pumped up right here. You were fired up, man. You were just getting after it. But I love the fact that, you were just you. You're being genuine, who you were, not really trying to be somebody that you're not. I mean, I can see that that's your personality, coming out, really competitive, but it was just natural, and I like that. I like the fact that you're standing up here and just like every other student, relying on no notes, but just on your own independent command of facts. That was absolutely impressive, both of you. You did a fantastic job too. There were some instances where you had to adjust based on some responses that you got from witnesses, and you were able to do that on the fly, and it was a seamless transition. I mean, you guys just had good composure, and that was absolutely impressive to see.
Thank you, Your Honor.
And you're welcome. And in terms of our witnesses, man, our witnesses were fantastic. The witness, Mr. Lucky, I love the way that you were really working hard to make consistent eye contact to really appeal to my passion, my sympathy, and my emotions. You did a good job of really making a lot of eye contact and really speaking to me. I really appreciate our expert witness on the defense side. Man, once you delivered your testimony, I thought that's a done deal right there, man. I'm persuaded. So that's one person right there that definitely had the experience, the training, education, and also the confidence to deliver unequivocally. Hey, there's too big of a gap right here. What are we talking about, folks? And you did a heck of a job persuading me. So nice job with your particular testimony. But all witnesses, you've all done such a remarkable job, outstanding job. Again, it's a testament to the time that you've put in, the preparation, and it's absolutely impressive to see that you've done that. And I give you a great deal of credit and a lot of kudos for an excellent job. I mean, you guys are the best of the best. You're here for a reason. And no matter what anyone says, you are the best and brightest here in Monterey County, and I appreciate you.